All right, we are here today in the matter of the Lirondell Tennis Club. It's case number 24-09 and 24-13. And it's William Polshak, Michael Stelmack, and myself, Joseph Evans. And we're here for the public deliberation in this matter. We held our hearing. The hearing was held on February 28th, 2024, and it was an in-person hearing. So the request here, the bottom line is that the request here is for a forest conservation easement. That's in 24-9. And 24-13 is to grant a variance, a stormwater management variance. So those are the two questions: the forest buffer conservation easement and the stormwater management variance. Correct? Is that correct? Did I get that right?
That is my understanding.
Sometimes I get lost in this stuff. There was a third one, but it was voluntarily dismissed. All right, so the standard for a forest buffer variance is in the Baltimore County Code. And that standard is that we can grant a forest buffer variance for those projects or for those activities where strict compliance with the requirements of the title would result in practical difficulty or unreasonable hardship. And the standard for a stormwater management variance is similar. It requires exceptional circumstances, and those are defined as circumstances such that strict adherence to the provisions of the title or design standards would result in unreasonable hardship or practical difficulty and not fulfill the intent of this title. So we heard from several witnesses called by the tennis club. Eric Hadaway was their, I think, primary witness, but they also called the two county witnesses who were involved significantly in the county's approval of both of these matters, both the stormwater management variance and the forest forest buffer conservation easement. So even though the county officials who reviewed this matter approved it, nonetheless, our review is de novo. So we don't have to accept what the county said. By the same token, the two people from the county testified as to the logic and rationale of the county's original decisions in each matter, and so they were highly relevant witnesses, even if they are not even if we don't have to ultimately, even though our review is de novo. There's a question about whether we should defer to some extent or legally defer to their judgment. I'm not sure, honestly, whether we do or not, but so I wouldn't want to go there, but at least putting that aside, but it is at least relevant that these are people with significant experience in their respective fields and worth listening to. The protestants presented no expert testimony. Their complaints were multivocal, let's say, if that's a word we could use in this context. And oftentimes probably exceeded the strict bounds of the precise issues in front of us. So, I mean, we do, it's not, we're not here to decide, for example, whether the club was fair in its procedures when it decided to make these changes. That's really not, that's not our beef. And we are really, we're also not, I think, ultimately, our decision doesn't turn on whether pickleball is a useful activity to have in these locations as pickleball. And whatever, I think we're all aware of, generally speaking, that pickleball can be irritating to people who live near it. I've never played it, I've never seen it, but I understand it's loud. Anyway, that is not our task. So I think that spells out the contours of where we are. Does that make sense to the two of you in terms of an overview?
Very well put. Thank you.
Exactly.
I'm a great believer in not pretending I don't have a view and then, surprising everyone at the end with what that view is.
I'm very interested in knowing what your view is.
My view is that the club has satisfied its burden of proof, and that the two matters before us should be granted. This is not to say that I don't have sympathy for the protestants. I do. But when we just look at the law and what the law requires and what the law dictates, and the proof offerings from the club and the proof offerings from the protestants, I think actually on balance, the club's evidence was, as far as I'm concerned, convincing and more than adequate. I mean, it was largely attacked by cross-examination, and Mr. McCann's very, very good at that. He's very good at that. But at the end of the day, I thought those witnesses held up and said, and well, I mean, they convinced me that the easement and the variance should be granted. So those are my views of this matter. And so what do you guys think?
Well, I'll go up, and
Okay.
in the cases and all the evidence were very compelling on all, from the county expert witness to Mr. McCain, Mr. Mudd, and I agree with you too, that the evidence and that makes it very clear. But I will tell you, I because it was brought up into our courtroom and discussed, and there was another expert witness, and that was Mr. Knott, who is an expert in his community. He's lived there. There's no better expert in a community than one who lives there. And since noise was brought up, it is a concern. to a degree. And we heard from an expert witness about it. That was Mr. Knott. And I do agree with the findings that they make all the variants approved. But since it was brought up in our courtroom, if there is any conditions that could be put on it, very basic, that may be able to, I know in courts, there's probably not a lot of both winners in cases. And you follow the law, and that's how it was applied. But since it was brought up by a witness in the court, if there is a condition that could be granted, I'd like to talk about it. May not be able to, but if it could, I would love to see a basic condition put in, if possible.
I certainly want to echo your sentiment about Mr. Knott's testimony. He was an exceedingly good witness, and it is quite fair to say that people who live right in the middle of a community are oftentimes the best gauges of how some requested change impacts that community. There's no question about it. I think oftentimes we overlook this, but I think it's a very well taken point. Now, I'm not sure the noise is part of the stormwater management plan, and I'm not sure noise is part of the forest buffer conservation easement as such. So we'll have to, we need to think about that.
Okay.
But there's certainly, we certainly have some moral suasion, I think. There's some institutional oomph. Maybe we could encourage the club, at the very least, encourage the club to take seriously the noise issues. I think the club ought to, just out of civility and consideration, if for no other reason.
And, certainly it's possible that the neighbors have some other relief available to them outside of this,
Meaning what?
Meaning as far as, well, I don't know that it's appropriate to suggest what relief they might have, but, as far as, except a noise complaint or,
yes, right.
or what have you, you know what I mean?
Right.
Same thing anyone would have in a situation where someone next door is making excessive noise, right?
Right. They can file nuisance claims, and I'm nuisance in the legal sense, not in the
Sure.
colloquial sense. It's a pretty cumbersome remedy, but it's there. It is there. Does that mean that you're in general agreement that the two requests should be granted?
I am in agreement that this will move through with the two variances being approved. But because it was brought up in the courts and on not through hearsay, but he was in actual meetings with discussions, and we know, look, from the testimony that it's been a long-standing company there. It's club. It's been with the neighbors. And many neighbors are members, which shows a great thing about the club. But because of the noise issue came up, it's very minimum conditions that could be put in. Maybe close the racquetball courts 2 hours prior to closing of the court, and I don't know when the courts closed or when the club closed, but some basic conditions that may be able to, since it was brought up in court. I was just, but if it can't be done, I agree with the findings of
Right.
the variances being approved.
Yeah, I'm not convinced it can be done. I don't know. What do you think, Mr. Stelmach?
What can be done? I'm sorry.
Specific restrictions regarding noise.
Oh, I mean, I just don't think that's before us, you know?
Okay.
Yeah, I don't either. And I mean, it's a little bit the elephant in the room, but
Yes.
it's really not part of stormwater management variances and things
Correct.
like that. If this were a special exception,
Yep.
something like that, a zoning variance, you know, then it would be central. And also, I mean, I also think it's fair to say that the testimony about noise levels was a little indirect. I mean, we had Mr. Knott citing the studies that had gone on, but you know, the club didn't really make and rightfully didn't make an effort to rebut that, and it's a little, so it's, you know, it's not really well, it's not before us, actually.
Correct.
I think it's fair to say. So,
Darren, if I just kind of get out the stuff that I had and
yes, please do. Please,
yeah,
please, yes, please do. Please do.
You had asked, you know, to what extent are we supposed to defer to the judgment of, you know, the expert in the county? And I take the structure of this, the de novo review, as we sit in the shoes of the director who's got this application before him, and that's kind of how I looked at this. And what was submitted before the hearing and at the hearing is essentially the application. So to the extent that all of the exhibits were admitted in the evidence and the expert witness testimony, you know, in a sense, that is what I took to be the application. And our job is to decide whether or not the application is approved or not, just the way the director would. I mean, that's how I took. This is the first time I've had one of these cases.
Mhm.
But what you know, looking at both the memorandums, I think the hardest thing for me is that we were given no examples of what constitutes a practical difficulty or an unreasonable hardship. And so we're kind of left with our own understanding of what does that mean. And you know, both sides made arguments about what they mean if it's a practical difficulty or a reasonable hardship. You know, it would be nice to have a little case law to be able to look at and say this is what it is or it isn't. But maybe there is no case law on the subject at all, and we're sort of left on our own. But you know, I don't understand. I mean, I guess, you know, from my perspective, because of all the particular circumstances of the site, you know, they are effectively rearranging the way they use it in a sense. I don't know why that can't be a factor in the calculation. And, you know, I think that the environmental engineer and the county took into account a lot of the environmental factors that is supposed to be why these regulations exist to protect the environment. And I think at bottom, it looks to me like there is not a lot of detriment to the environment here. And
it's arguable there's an improvement. Arguable.
It's arguable, yeah. And in fact, you know, part of that is that the county has imposed, and I guess we would also, if we agreed to allow the variances, to impose a number of mitigation efforts that the club would have to maintain to mitigate, you know, the situation. So, you know, I think the facts are compelling as far as the analysis that was undergone to allow for the variances. So, I would be in agreement with you gentlemen that I would allow the variances.
Okay. Anyone have any further comments to make on this? Okay, well, I think we have a unanimous agreement then that and I think your point about incorporating in the restrictions that were in the county's approvals is excellent. I think we should do that. It's a good point. So with that, with those limitations, and with a suggestion from us that the club do something about the noise to the extent possible, would be also nice. But I don't think we can make that a formal restriction or limitation. But it is, you know, it would help everyone get along if the club would make some more than good faith efforts to remediate any sound disturbances. So, well, with that, I think that's a fair summary of what we've decided. And so with that, I think we will adjourn, and a written opinion will be issued in due course.
In due course.
In due course, yes. I was about to say forthwith, but I know us better than to say that. So, so I think in due course is a safer word there. Yeah.
Sure.
Okay.
Thanks, gentlemen.
All right.
Thank you.
Thank you.
Thank you.